So, what happens when two sides tell completely different stories in a courtroom? Who gets to decide what the truth is? You'd probably say a jury of your peers, right? But what if a judge can step in and call the whole thing off before it even starts? It's a huge question, and we're going to explore it through a really powerful legal tool that gets right to the heart of our justice system. And we're going to see how this plays out in a pretty gripping real-life case where one man, an inmate, took on the entire system. And the answer to this question, well, it changed everything for him.
It sounds like such a simple question, doesn't it? I mean, we're all taught that juries are the ones who figure out the facts, but it's not always that clean. There's a legal move that can stop a case dead in its tracks, and it all boils down to one key concept. And that concept is called summary judgment. Okay, think of it like a shortcut. One side says to the judge, look, even if you believe every single thing the other side is saying, we still win based on the law. There's literally nothing for a jury to argue about here. It's designed to be efficient, to save everyone time and money on cases where there's no real fight over the facts. But what happens when there is a fight? To really see how this works and how it can go sideways, we have to look at the case of John Anthony Spencer. He was a federal inmate who decided to fight back, acting as his own lawyer from inside a prison cell. It all kicks off in late 2012. Spencer refuses to do a deposition for some outside case. And almost instantly, things start to happen to him. And I mean fast. He gets hit with an incident report.
Okay, so this is the incident report right here. So I just want to draw your attention to the date, 12/17, right? Because I can't highlight it, but it says, inmate stated he did not show up for the call out because the compound was not open. Stated he waited for staff to call him down. And I also said I didn't want to do the deposition. But it says, based on inmate's admission to willingly missing call out. Did I admit to missing the call out, or did I say I couldn't come to the call out because the compound was closed? This is the type of adjudication that people with criminal justice degrees all the way up to judges are trained to give. And so let me ask you something. Did I admit that I unwillingly didn't show up to the call out? No, fucking of course I didn't. Right? But that's why I say it was all pretextual. The government's official record is just documents like this based on absolute bullshit. So this is the second part to that. Remember, I'm saying that they're trying to intimidate me from filing appeals, filing grievances. And if you look at the affidavit case and just look at it, you know what I mean? And go on Pacer and look at some of this stuff. But this is from that incident report where they say they use my statement to concur that I made this violation, right? And if you remember my statement, I admit to willfully missing a call out. The compound was closed. And here it says that the inmate was advised of his right and he stated he understood them. Inmate stated the incident. He had told staff he was going to take part in the telephonic deposition. And if he was going to be forced onto the call, he felt it was a violation of his rights and the BOP had no right to make him do this. Now, doesn't that seem reasonable, right? You're talking about me getting into a legal proceeding. You're going to make me do it. And I'm saying you can't make me get on this phone and testify in a deposition. You can't make me do that. And they're saying, that we could. And so there was that argument. And then they tried to spin it because they really couldn't punish me for that. So they had to make up something to punish me, right? You understand? And look at right under that where I talk about asserting my rights. Look at what they have written right there. This inmate had a poor attitude, right? Because to them, arguing for my rights is the poor attitude. And that's exactly what I'm saying. And the evidence is full of little hints like this.
He gets hit with an incident report. He's turned into solitary. His legal papers get taken away. And then he's shipped off to a higher security prison. To Spencer, this was just way too much to be a coincidence, so he filed a lawsuit.
So at the end of all this, and this is the docket, right? This is the case right here, 13 CV 00177, and this is while my direct appeal is going on, while my 2255 is going on. And David McLaughlin called up to the prison because my co-defendant, Patrick Doles, recanted. So here you go. You see what this says? This says on January 8th, 2013, documentation was received from AUSA David McLaughlin stating inmate Spencer should be separated from inmate Doles Patrick. Doles arrived at FPC Duluth on January 3rd, 2013 due to inmate Spencer being under investigation for running a business. In the opinion of the AUSA, it was decided that inmate Spencer would be transferred. And the opinion of McLaughlin. That's what it says, right? That implicates him. Part of their reasoning, we don't know, maybe a major part, was that opinion, that discussion with David McLaughlin. Now think about that. McLaughlin just sentenced Patrick Doles about a month ago, right? And he knew at that point that I had wrote Patrick a letter in support. I told the court, let Patrick off, man. He did everything you asked him to do. Why do you let him go home now? And they talked about that letter in court. Patrick Doles thought he had immunity, but he found out in that sentencing hearing that he didn't. And then also leading up to that sentencing hearing, in a letter to the court, he said that he never intended to commit fraud, and that recanted his trial testimony. And at the same time, McLaughlin knows that I'm arguing these things about him specifically, and he knows I've been silenced thus far on appeal. I tried to fire my attorney. They didn't let me. They just rolled on without me. He knows all that. And so now he's saying he waited until the 8th to call the prison, knowing Patrick was going to get there on the 3rd. I don't believe that for a second. In fact, one of the guards at the prison told me that McLaughlin had actually called and had talked about this before Christmas. And so that coincides exactly with when I got thrown in the hole and all my legal work was taken, doesn't it? And so now that Doles has just been sentenced and he's on his way to the prison, they need some reason to keep Doles and I separated. And this gave him the opportunity to pierce my legal work privilege, right? Get into my legal work product, which is supposed to be confidential, and sift through it under the guise of some purported business and extract the exculpatory materials that I had and send me off to the next spot without them.
And Spencer's claim was a big one. He argued this wasn't just random bad luck or routine procedure. No, he called it a coordinated chain conspiracy. He believed multiple prison officials were working together to punish him for being a jailhouse lawyer, for working on his own criminal appeal, and for helping other inmates with their cases. A huge piece of his case came down to a single, simple number: 12. 12 inches. When his property finally caught up with him at the new prison, a foot-high stack of his legal paperwork was just gone, vanished. And here's the kicker.
Let me show you the proof. This is in case 13 CV00177JNE JSM. If you just want to get this document, you can get it at document 149. This is page 1 of 5, but it has some attachments. Let me show you. So this is the declaration of Patrick Thing, where he tries to create some explanation for my missing legal work. So we're going to go down now to, so he throws in this policy statement, right? They throw all this junk in to try to say that they were in accord with this policy statement, right? But what they did is they read the policy statement and then they gave their narrative of what happened, right? And then they all agreed to it. Let's go down here. As you see, they already said I admitted something I didn't do. That's a pretty common theme with them, as we know. That's the easiest way. If you admit to it, they don't got to do no work. Okay, so here is what's called an inmate personal property record. And so let me go ahead and get this calculator open so we could do some math. But we got 26 inches of legal materials here. So we'll go 26 and we're going to go down. Okay, so this is signed inmate not present. That's important. Come down here. Here's the next one. And we've got 12 inches of legal materials. So let's add that. That gives us 38. Am I right? Again, inmate not present, 221.13. Now is the third one. Here's all the books, right? So this kind of just shows that I had this stuff. This is, again, I'm not present. This is the government. This is their document. I don't know who this is. Now let's go down to when I arrive at the new prison, right? And now look at the date here. And I am here and I sign it. It's 3/1, right? 3/1. So that's a lot of time that's passed, hasn't it? To go to 2 prisons in Minnesota. Would you agree? Anyway, let's go down here. We've got 26 inches of legal material. So let's minus 26. Ooh, that gives us 12. And let me get that calculator back on here so you guys can see it. You tell me. And so this is the second page, right? You tell me. That's the only one that there is too. You see, this is the document. This is court filed document. They filed this. Okay, so it seems to me that I'm missing a foot of legal work, that it proves my innocence. And they're going to hold me in prison even though they lost it. So if I was given a trial, I was going to simply call people to the stand to establish what was lost. I would call Patrick Doles. I would have called some of the other witnesses who had reached out to me. I would have developed the new evidence to show them in the civil case, this is what was lost. But as you'll see, there was no way they were ever going to let that happen. Right? And because of its high probative value, that's why it was taken. You would have to be looking for it and understand the level of probative value to specifically take this foot out of 38 inches. You took specifically this 12. When it was almost getting time for a trial, it's about that time to maybe start thinking about a trial. They move for summary judgment and they submit to the court all of my past pleadings in the criminal case, showing that I tried to fire my lawyer. I was trying to raise these claims. And they basically let the civil court know that I was essentially trying to litigate my criminal case through this civil case. But the facts were that was my right at this point. And they wanted to prevent that at all cost, all the way to the point to mischaracterizing the evidence, saying there was none, saying all I had was self-serving statements, despite what really they had were self-serving statements that when you look at it, don't line up with the actual record.
This wasn't just his word against theirs. The prison's own property logs created a factual dispute right there in black and white. You can see it here. The log from the prison he was shipped from recorded 38 inches of legal materials, but the log from the prison he arrived at, only 26 inches. That's a 12-inch gap documented by their own system. So Spencer's lawsuit laid out this whole pattern of obstruction. He claimed those missing documents were vital for his criminal appeal. He said staff kept denying him the basic forms he needed to even file a complaint. He was even threatened with something called diesel therapy. That's slang for being put on a bus and endlessly transferred from prison to prison as a form of punishment. But, of course, that's only one side of the story. The government and the prison officials, well, they had a completely different take on what happened. They said every single action they took was by the book. The officers all filed sworn declarations, basically official statements, denying everything. This quote from an officer, Anderson, is pretty typical, just a flat-out denial of what Spencer claimed. It sets up a classic he said, they said situation. And this is where you see the two stories just completely collide. Spencer saw retaliation, the government saw legitimate procedure. That disciplinary report? Oh, that was for an unexcused absence, they said. The transfer? That was just routine policy because one of his co-defendants showed up at the same prison. Two totally different realities. Now, the government's defense was pretty clever. First, they argued Spencer had no actual injury.
Their logic? Well, even after all that, he technically still had 2 weeks left to file his appeal.
And listen, I don't know if I had 2 weeks when I got to the new prison and got my thing. All of the things missing and disorganized in a mess, I didn't know what was missing right away. So it took me some time to go through it. And then once I did, none of the stuff that I needed to file my appeal was there, which would have told me what the deadlines were. They said, well, technically you could have asked for an extension. So that was their argument. And you know what I mean? That's what the court said. You got off and you had 2 weeks. You might not have had anything, but you still should have done it in that 2 weeks.
They said their investigation was perfectly valid, and then they pulled out the ultimate trump card, qualified immunity. That's a legal doctrine that makes it incredibly hard to sue government officials.
So what do we have? We have two starkly different stories. We've sworn statements on both sides, and we have a piece of hard evidence, those property logs, showing something is definitely off. This seems like a slam dunk for a jury to sort out, right? You let them hear both sides and decide? But that is not what happened.
The judge granted the government's motion for summary judgment. Case closed.
So when I said there was a lot of controversy and people contradicting each other, and there was questions for the jury, well, this is the affidavit of the guy who came in with another investigator and threw me in the hole, took all my legal work, sifted through it, then had to come up with an excuse for it, right? Because, you can't do that. So this is Doc 147, filed January 8th, 2016. When you come down here, he says that he found this was recovered in my property, he claims. This fee structure sheet that they say shows I was charging for legal work. They say they found this. The evidentiary, declaration attached with this, I guess, is this December 24th, 2012. Remember these dates. And it's W. Johnson, the same W. Johnson who said I admitted to willfully not going to the call out when that's not what I said. And so it's him again. And this is from E. Landin, L-U or L-A-N-D-I-N. So, Johnson and Landon here, and they're talking about me, and they're saying that on 12/23, they were inventorying, or this guy was inventorying, and they found this fee structure thing. It described my business fees, and they also located several folders of legal work belonging to other inmates, right? That's what they say the next day, December 24th. Keep that date in mind. Now, let me show you this document filed on the same day. This is 146. This is the declaration of Daniel Gravdos, another defendant in my civil case. It's the other guy who came into my cell, got all my legal material, sifted through it, had it on the desk with me handcuffed there, sifting through it, and this guy, right? Go down to the bottom here. This is his affidavit. But remember the Lieutenant Johnson memo from Landon? Landon said he searched my property on the 23rd. Well, this is the inmate property record from the 23rd. You see that up there, the 23rd? And you will find nothing in here. And like I said, nothing in the contraband confiscation forms in this matter that has anything to do with other inmates' property or anything. And this guy, he signed this on 12/23/12. Look at it. It's not Landon either. It's some J. Rajalashaw. It's not even the same guy. And there is nothing documented from anybody named Landon. Now, this is the day before, right? And there is no discussion. No one has found any contraband, anything from other inmates, anything. Okay, let me repeat. This is a request for legal work at the bottom here, and he's giving me some pretextual answer that while I'm in the hole, I can only have so much, and I know that, but I don't have any. They're not giving me any. So Doc 146, look it up on Pacer in case 13 CV 00177 JNE JSM, and I didn't sign any of this, as you see, and there's nothing that was discovered on the 23rd. This is at 6:30 p.m., so there's nothing discovered in inmate property that, backs that up, right? So the record is devoid of this claim, and this fee thing and this letter come the next day by somebody who's not even involved with inventorying my property. So do you see that? All this stuff was before the court. So now when they were trying to dismiss me for summary judgment, right? I laid it all out factually, submitted a lot of evidence, right? A lot of evidence. The same evidence that I used when they tried to dismiss it for not having exhausted my administrative remedies. Like that was a big deal just like this. They tried to get it dismissed and they argued that I didn't exhaust my remedies. But I proved to, the burden of the law that I did and they prevented me, right? That's already on the record, right? It's already established that these defendants actively prevented me from accessing the prison grievance system. So keep that in mind as the court makes its ruling that, I don't have any evidence, but I had a bunch of evidence, bunch of exhibits that I sent in, affidavits. And when you go through it, there's over 100 paragraphs here. And if we go down to page 42 of this document, right? 42 of 42, and then kind of my attachments and different memorandums of law and stuff come in. I swear under penalty of perjury that the foregoing facts, paragraphs 1 through 111, are true and correct, right? So verified under penalty of perjury. And then remember, they had their own attorney come out to the prison and depose me for like 3 hours, right? And there was a transcript produced. That's also evidence. And that's evidence where, I'm being cross-examined by a hostile opposing counsel and there's no inconsistencies, right? So that's evidence too. And they completely omit that, you know what I mean? Like that doesn't matter. So this is the report recommendation. This is what the court used to adopt it. I'm not going to go through the whole thing, right? They basically say there's no material questions left because the defendants have alleged some things, and then they kind of misquote different things, right? Like, let's go down here. Number 20. This is their big thing, right? Is that the court doesn't have to believe me if my versions of the facts are so blatantly contradicted by the record. Are they, though? that no reasonable jury could believe them, right? So you could be a reasonable jury member and you're seeing what I'm saying. Could you believe me, right? And they're saying that the plaintiff may not merely point to unsupported self-serving allegations. Now, if you really look at everything that I filed, a number of my filings actually came with a witness, right? That was willing to put their name under penalty of perjury and say, you know what, I was here, that's what happened. We'll keep going down now. I want to bring you down to, I think, page 51. And you can get this. This is document 165, case 13 CV 00177. Remember the job change? Again, this, I don't have any evidence, supposedly. It says here in the footnote, plaintiff did not flesh out the retaliatory nature of his job change in his amended complaint or statement of facts. Consequently, the court has no idea why the kitchen assignment would be less desirable than the recreation department assignment or some other assignment, much less why it even amounts to punishment or discipline. At his deposition, plaintiff testified that he wasn't interested in doing the kitchen job and that he didn't really want to work in the kitchen, right? And so this is the first case where they kind of tried to take a deposition where they've got their attorney asking you questions. And if you really look at the deposition, there was arguing and banter going back and forth, but they can't get why being in rec would be better than being in kitchen. And they don't understand that Anderson is mad, so he changed it. So like, why would Anderson change it if it wasn't a punishment? And why would it be listed under the UDC as a punishment, as a sanction, if, it wasn't a punishment? But the court can't figure that out. So I apparently didn't flesh out to them that the UDC hearing, the actual paperwork for that, it records that I said I couldn't come to the call out on time, not because I was unwilling, but because the compound was locked and I was waiting to be called to it. And I arrived as soon as I could. They'll admit that and then say I admitted it. And then they're here talking this nonsense. So let's just, right? I just want you to compare this right to the probation hearing that I showed you, right? You can hear the actual hearing where they say I didn't tee up the argument for the farm bill. It's not teed up. And just listen to that. That will give you all the flavor you need to understand what's going on here and interpret the docket, interpret these court rulings. If you listen to that hearing, you're going to know exactly what I was up against in this hearing and what every defendant in the federal system is up against. There's a big one. One of them is the due process claim where they talk about my legal work, right? The 12 inches. That's important, right? Is that it? I got a cross motion. I got a motion for sanctions, right? Because they're basically lying. I'm pointing out that they're lying, right? Their own statements are contradicting. So they claim the reason why their statements were so inconsistent is because they hadn't been able to do discovery yet. And they're the people in charge. They're the people running the show. They didn't know what was going on until they did discovery. They had to come into my jail cell, I guess, and get some discovery from me to know what was going on. Unbelievable, guys. You had to read this for yourself. But we got to get to the UDC hearing legal book. So this is where they mischaracterize the declaration again. When I'm being deposed, I'm getting a series of questions about this and that. And the discussion was that, yes, I did have some books that belonged to other people. I could have the books that the inmate borrowed. That was something that was allowed. An inmate could borrow me a book to read, right? And so you can't have it. They made these ridiculous arguments, right? That didn't make sense. So I pointed that out. Their arguments don't make any sense. And they use this as a pretext to take some things, right? And so when I was in the SHU, what they asked me is this stuff that, belongs to other inmates. Can they have it back? Yes, please. I borrowed that book. Give it back to them. Again, they're trying to say that I admitted to having some type of contraband. I never did. I said the stuff that I had, I was able to have. And then you guys took it, sifted through it, and took the most important parts and then said some of it was illegal or contraband. And that's how you justified what you did. That's what I said, right? So and that's in there. You can read it. That's what I said. And so that contradicts everything that these people are saying. And they don't have any proof. They just have their word. And if you look at the actual record, the timelines don't match up. Nothing matches up to what they're saying. But we go down to the bottom. And on a motion for summary judgment, the court is entitled to reject fanciful and far-fetched statements that have no support beyond the plaintiff's own testimony. Right? That's what they claimed, and they denied my motion. And I should have got a jury trial because that's not the purview of the court to make these credibility determinations. It's for the jury to decide who they believe. And so what that should show you is that when you're in prison, they can do anything they want to, and they can deny you a jury trial just because the fact they can isolate you. Imagine they isolate you in a room and they beat you every day. And then they leave you there for a few weeks until you heal up. And it's not until a year later you're in general population. How would you ever prove that? Right? But that's what they're saying. That's what this ruling represents. And that's why it should really shock your conscience. And that's why you should hit that petition for me, because at every level, this was manifestly corrupt. It was a fraudulent fake conviction. And then they use stuff like this to deny me my appeal rights and make sure my deadline's passed. Fraudulent. But you can find this document 165 in case 13 CV 00177. They make all these improper determinations on the jury's behalf because they never want this to go to trial where I can develop a record. They're going to deny me that. Just like you heard in the probation hearing. Go back and listen to that. It's the same level of adjudication. It's all manifestly fake, fraudulent, and corrupt.
And the court's entire reason basically came down to one phrase: self-serving. The judge decided that Spencer's own testimony, his own story, wasn't enough to create a real dispute that a jury needed to solve. Okay, so what does self-serving actually mean here? Well, legally, it refers to statements from one person that only help their own side without any other proof. The problem is, by using this label, the judge isn't just looking at the law. They're weighing the evidence and deciding who's more credible. But wait a minute, isn't that the one job our system says belongs exclusively to the jury? And this is what's so wild about this case. How could a court say Spencer's claims were unproven,
He had the prison's own documents showing a 12-inch discrepancy. There were inconsistencies in what the officers themselves said. He even had evidence that they punished him before his disciplinary hearing ever took place. By calling Spencer's testimony self-serving, the judge essentially chose to ignore all that. They made a call on who to believe, and in doing so, they shut the whole case down before a jury ever heard a word.
An outcome like this really forces you to zoom out and ask a much bigger question about the power of a judge versus the power of a jury, especially in civil rights cases. Because, the Supreme Court has actually been really clear on this. The rule for summary judgment says the judge is supposed to look at the evidence from the perspective of the person fighting the motion. In this case, Spencer. His story is supposed to be believed, and all the reasonable conclusions are supposed to be drawn in his favor. A judge's job isn't to pick a winner. It's just to see if a reasonable jury could find for that person. So that leaves us here. In a he said, they said fight, especially against the government, how much proof do you need just to get your day in court? If documented evidence, like a prison's own logs, can just be brushed aside because a person's story is labeled self-serving, then who really gets to decide the truth? The judge or the jury?
I'm going to show you what some of the first petitions look like in this case. Now, guys, they also said, despite the fact of everything that happened to me, because I could, fight my case, it proves I wasn't hindered. And so just think about how hard it must have been to file this. Now, look, I want you to see some of these docs here, right? Hopefully this is going to carry doc 1. This is what I had to write on, right, to make this complaint when I'm in the hole, right? And I had to have someone else mail it for me. It had to be snuck out, literally, right? Here's the second doc, right? Affidavit of poverty, I'm in the hole. I can't pay the filing fee. I need help. Here's the second doc. Here's another motion. I'm asking for help. They're all handwritten, right? This is document 7. This is an affidavit. This was filed January 17th. I think it was signed before that. This was signed on the 10th, right? So this is the 10th. Just want to show you something in here. Affian's legal work product has been confiscated by the staff at Federal Prison Camp. And they've confirmed that they've got it. They're going through it. They're examining, they're reading, they're investigating, otherwise breached my privilege, right? All this is being alleged in an affidavit very early on, long before the defendant's statements in 2016. And they tried to put it down. They were like, you need to pay a minimum filing fee. And I'm like, well, I'm in the hole, right? I don't have anything. I'm asking for legal supplies. They've transferred me now to a county jail. I don't have any money. I'm separated from my inmate trust account and I can't access it without them allowing me to. Anyway, how am I going to pay this, right? So I had to really fight to get through this, right? They're trying to deny my petition any way they could. Now, just in case you think I'm over exaggerating, look at this. They're doing some calculations here. And this is after I submitted that affidavit of poverty. I said I'm in the hole. The defendants are refusing to, make any payments on my behalf. I don't have any money to give you for this filing fee, but I have a claim. I need help. And they determined that if in 20 days I don't give them $2.62, right? $2.62. Until they get that, they're not going to hear anything that I got to say, and they'll dismiss my petition. Look at how many there were. There's 183 documents in this case. And they even sent out an attorney to depose me at the prison years later, 4 or 5 years after the time we're talking about right now. And you're going to tell me if there wasn't something to this case that this would just be allowed to go on for almost 200 pleadings in 5 or 6 years? Just think about it. My shoes for a minute. I'm trying to fight my criminal appeal. And this is a side issue that I have to deal with because they literally created a fake reason to go through my legal work, take my evidence, ship me off somewhere, and prevent me from really challenging my criminal case. And I'm saying this really since day one. They're saying I'm not hindered, but if you look at those filings, I'm damn near writing on napkins, right? And this case goes through, almost 200 documents are filed in this case over several years, right? Now, what do you think my time was like? Do you think the BOP tried to accommodate me and they were nice to me when this stuff was going on? How do you think it really went down, right? Do you think while I'm suing the BOP, but I'm also in their custody, you think that was a comfortable situation to be in that was, just without incident? Think about what type of resolve it's taken to sustain this fight this long, right? I stand on this. I'm asking you to sign the petition, help me get a fair hearing. I was wrongly convicted, and at every level after the conviction, they sabotaged, impeded, and manipulated the record to prevent me from ever having a fair day in court.